I knew something was wrong the moment I pulled into my driveway and saw the concrete trucks parked along the street. My name is Peter Richardson, and I had lived in the Meadowbrook Hills subdivision in Gilbert, Arizona for exactly 3 years, 2 months, and 16 days. Not that I was counting, but after what happened that Tuesday morning in March, every single day became etched into my memory with perfect clarity. The workers were spreading fresh concrete across what used to be the small access area on the eastern edge of my property line. More specifically, they were pouring it directly over my artesian well, the same well that had been documented in my property deed, the same well that had been drilled in 1987 when this land was still part of a working ranch, and the same well that provided natural spring water that bubbled up from deep underground without requiring any pump. I slammed my truck door and jogged toward the work crew. "Hey, stop! What are you doing?" A burly man in a yellow hard hat looked up from his position near the cement mixer. "HOA approved paving project. We're extending the community sidewalk." "That's my property," I said, pointing at the surveyor stakes that clearly marked my boundary. "And you just buried my well." He shrugged. "Talk to the HOA. We just go where they tell us." I pulled out my phone and called the HOA office immediately. A chirpy voice answered. "Meadowbrook Hills Homeowners Association, this is Deborah speaking. This is Peter Richardson at 4782 Saguaro Drive. There's a concrete crew pouring over my artesian well right now. I need someone to stop this immediately." "Oh, let me check." I heard typing in the background. "Yes, the sidewalk extension project was approved at last month's board meeting. It's part of our community beautification initiative." "I wasn't notified, and it's on my property," I said, trying to keep my voice level. "The HOA has easement rights for all community improvements. You agreed to that when you purchased your home." "Not over a documented water source," I countered. "I need to speak with whoever authorized this." "That would be Karen Lansdale, our HOA president. She's not available right now, but I can have her call you back." "When?" I demanded. "Within 2 business days per our policy." I hung up and turned back to the workers, but it was too late. The concrete had already been poured, smoothed, and was beginning to set in the warm Arizona sun. My artesian well, which had been capped with a simple steel cover that allowed me access to test the water quality and monitor the natural flow, was now buried under 4 inches of concrete and rebar. What the HOA didn't know, what Karen Lansdale and her board of petty tyrants hadn't bothered to research, was that I didn't just own the land. I owned the water rights, complete, total, and absolute water rights to that underground aquifer that fed my artesian well. Those rights had been grandfathered in from the original ranch, meticulously documented and recorded with the county. I had purchased this property specifically because of those water rights. In Arizona, water is more valuable than gold, and owning your own source is like having a winning lottery ticket. The previous owner had been an old rancher named Eddie Morrison, who had decided to subdivide his land when he retired. He'd sold most of it to developers who built Meadowbrook Hills, but he'd made sure that certain parcels retained their original water rights. Mine was one of them. I spent the rest of that day documenting everything. I took photos from every angle, measured the concrete coverage, and pulled out my property documents. Then, I drove to the county recorder's office and made certified copies of my water rights documentation. The clerk, a friendly woman named Rosa, noticed what I was copying. "Water rights dispute?" she asked knowingly. "HOA buried my well," I said. She whistled low. "They don't know what they've stepped in, do they?" Not yet. That evening, I sat at my kitchen table and started making calls. First, I contacted a property attorney named Gerald Simmons, who specialized in water rights law. His secretary scheduled an emergency consultation for the next morning. Then I called a water engineer I knew from my work as a commercial plumber, a man named Tony Reeves who had done assessments for me on several large projects. "Tony, I need you to do an assessment and put a value on something for me," I said. "What kind of something?" "An artesian well that's currently flowing under concrete." "Jesus, Peter, what happened?" I explained the situation. Tony agreed to come out the following afternoon. Karen Lansdale finally called me back 3 days later, exactly at the end of her 2-business-day window. Her voice had that practiced sweetness that couldn't quite hide the steel underneath. "Mr. Richardson, I understand you had some concerns about our sidewalk project. Your crew buried my artesian well under concrete without my permission, I said flatly. As I'm sure you're aware, the HOA has the authority to make improvements for the benefit of the community. The sidewalk extension was approved unanimously by the board. Did the board research my property records before approving this? We reviewed the plot maps and easement agreements. Did you review my water rights? There was a pause. I'm not sure what you mean. I own the exclusive water rights to the aquifer under my property. That artesian well isn't just a decorative feature. It's an active water source that I have legal rights to access. Well, I'm sure we can work something out. Perhaps we could relocate your well access. You mean drill a new well? At whose expense? The HOA isn't responsible for individual property features. I smiled, even though she couldn't see it. Actually, Karen, you just made yourself responsible. You buried my legal water access. My attorney will be sending you a letter. There's no need for lawyers. Mr. Richardson, I'm sure we can be reasonable about this. I am being reasonable. I'm giving you notice that as of today, your sidewalk is blocking an active water source that I own. Since I can no longer access it for my personal use, I'll need to bill the HOA for the water usage. Bill us? For what? For the water. It's still flowing under that concrete, approximately 40 gallons per minute based on the last flow test. That water has value, Karen. Significant value in Arizona. You can't be serious. Dead serious. You'll be hearing from my attorney. Have a good day. I hung up before she could respond. The next morning, Gerald Simmons sat across from me in his downtown Phoenix office, reviewing my documents with the focused attention of a hawk watching a mouse. This is ironclad, he said finally. These water rights are absolutely legitimate. Senior rights too, which means they take precedence over almost any other claim. Can I really bill them for the water? I asked. Gerald leaned back in his leather chair. Not only can you, but you should. They've effectively appropriated your water source. In Arizona water law, this is a serious matter. The fact that the water is still flowing means it's still being used in the legal sense. Since you can't access it for your intended purpose, and their infrastructure is now benefiting from the subsurface moisture and soil stability that artesian flow provides, you have grounds to claim they're using your water. What kind of value are we talking about? That's where your engineer comes in. We need to establish the flow rate, the water quality, and the market value. In Arizona, with our water scarcity issues, this could be substantial. Agricultural water rights sell for thousands per acre foot. Potable water is worth even more. Tony Reeves arrived that afternoon with ground-penetrating radar equipment and a team of 2 assistants. They spent 4 hours scanning the area, taking measurements and analyzing the subsurface water flow. When he finished, Tony handed me a preliminary report that made my eyebrows rise. The well is still active and flowing at approximately 38 gallons per minute, Tony explained. That's about 54,720 gallons per day, or roughly 20 million gallons per year. The water quality tests I'm basing this on from your previous reports show its potable quality, which in the current Phoenix metro market trades at premium rates. What kind of rates? Conservative estimate? About $8 per 1,000 gallons for potable groundwater rights. That's over $160,000 per year in water value. I stared at him. You're serious? Dead serious. And that's conservative. Some recent transactions have gone higher. Peter, you're sitting on a gold mine. Or rather, they're sitting on your gold mine. That evening, I calculated exactly what I was going to do. The HOA had buried my well on March 16th. Today was March 22nd. 6 days of water flow at the rates Tony calculated came to roughly $2,600. I drafted an invoice on my computer, printed it on professional letterhead, and mailed it certified to the HOA office. The response came faster than I expected. Karen Lansdale showed up at my door 2 days later, accompanied by another board member, a thin man named Douglas Werner, who served as the HOA treasurer. Mr. Richardson, this invoice is absurd, Karen said, waving the paper I'd sent. You can't seriously expect us to pay you for water that's underground. It's my water, I said calmly. It's documented in my property deed. You buried my access to it. The water is still flowing and providing value to the soil stability of your sidewalk. You're using my water, so you pay for it. Douglas adjusted his glasses nervously. This could bankrupt the HOA. You're talking about thousands of dollars per month. About $5,000 per month, actually, I corrected, which is why you should probably remove that concrete and restore my well access. That would cost tens of thousands, Karen protested. The concrete is set, there's rebar, landscaping. We'd have to tear it all out and redesign the sidewalk route. Should have thought of that before you poured, I said. This is extortion, Karen hissed. No, this is business. You used my property without permission. You buried a documented water source. Now you're benefiting from that water's continued flow. In Arizona, water law, that makes you responsible. My attorney can explain it if you'd like. Gerald Simmons did exactly that when the HOA's attorney, a nervous young man named Patrick Chen, contacted him the following week. I sat in Gerald's office while they had a conference call. My clients are prepared to offer a one-time settlement of $5,000 to resolve this matter, Patrick said. Gerald looked at me and I shook my head. My client declines, Gerald said smoothly. The ongoing use of his water resource requires ongoing compensation. However, we're willing to offer an alternative. The HOA can remove the concrete, restore well access, and pay for all damages and restoration costs. We'll waive any back billing for the water usage during the period the well was inaccessible. That would cost $40,000 to $50,000, Patrick protested. Yes, it would, or they can continue to pay approximately $5,000 per month for water usage. Over the course of a year, that's $60,000. Over 5 years, $300,000. Your choice. There was silence on the other end. Finally, Patrick said, I'll discuss this with my clients. The next HOA board meeting was scheduled for April 7th, and I made sure to attend. The community center meeting room was packed with residents who had heard rumors about the dispute. Karen sat at the head table with 4 other board members, her expression glacial. When they reached new business, Karen addressed the crowd. We have an unfortunate situation with one of our residents who is attempting to extort the HOA over a minor property issue. That's not accurate, I said, standing up. The HOA buried my artesian well without permission. I own the water rights to that well, which are documented and legal. I've simply asked for compensation for water I can no longer access because of the HOA's actions. A woman in the back raised her hand. How much water are we talking about? About 20 million gallons per year, I said, worth roughly $160,000 annually at current market rates. The room erupted in conversation. Karen banged her gavel. This is ridiculous. No one person owns that much water. Actually, I do, I said, pulling out my certified documents. These are my water rights, recorded with Maricopa County. They're senior rights, which means they take precedence over newer claims. The HOA buried my access to this water and is now benefiting from its continued flow under that concrete. Douglas Werner looked pale. If we don't pay, what happens? I file a lien against the HOA for unpaid water usage, Gerald said, standing beside me. That lien attaches to the HOA's assets and potentially to every property in this subdivision. Your property values would be affected, and any real estate transaction would require addressing the lien. Another resident, a retired man named Frank Jacobson, stood up. How much would it cost to fix this properly? To remove the concrete and restore proper well access, approximately $45,000, I said. Or the HOA can continue paying me about $5,000 per month for ongoing water usage. How much has been billed so far? Someone asked. Approximately $8,000 for the time period since they buried the well. Karen's face had turned red. We're not paying this. It's blackmail. It's property law, Gerald corrected. Your HOA made a decision to build on Mr. Richardson's property without proper research. You buried a documented water source. Now you're facing the consequences of that decision. The meeting dissolved into chaos. Residents argued among themselves about how to handle the situation. Some sided with me, saying the HOA had overstepped. Others worried about the cost implications for their dues. Karen kept trying to regain control, but had clearly lost the room. Over the next 2 weeks, I continued to send weekly invoices to the HOA. Each one detailed the water flow, the calculated value, and the accumulating total. By the end of April, the bill had reached $15,000. The HOA still hadn't paid a cent. That's when things got interesting. Karen and two other board members, a woman named Phyllis Carter and a man named Robert Hughes, decided to take matters into their own hands. They contacted a concrete contractor and, without board approval or my permission, had the contractor pour an additional layer of concrete over the well area, apparently thinking that if they sealed it better, they could claim the water was no longer flowing. And I watched from my window as they did it, documenting everything with my phone's video camera. When they finished, Karen walked up to my door and knocked. "There," she said triumphantly. "The well is completely sealed now. No water flow means nothing to bill for." I smiled. "Karen, do you understand how artesian wells work? The water comes up from underground. If it's sealed, it can't come up. The water's under pressure. It's going to flow somewhere. You just redirected it." I gestured to Tony Reeves, who was standing in my driveway with his equipment. "We're about to find out where." Tony spent the next 3 hours scanning the area with ground-penetrating radar and monitoring equipment. What he found was both predictable and damaging. The water, unable to flow through its original outlet, had begun to pool underground and was now seeping laterally through the soil, creating subsurface moisture issues under multiple properties, including 3 homes on the adjacent street. "This is actually worse," Tony told me, showing me the scans. "You've created underground water pressure that's undermining foundations. In about 6 months, those homes are going to start seeing cracks, settlement issues, and possibly serious structural damage." I looked at Karen. "You just created a liability that's going to dwarf my water bills." Her face went white. "We were just trying to stop the leak." "It's not a leak. It's an artesian well. The water's under natural pressure from the aquifer. It has to go somewhere. You didn't stop anything. You just turned it into a foundation problem for your neighbors." One of those neighbors, a woman named Sandra Mitchell, had been standing nearby listening. "Wait, you're saying our foundations are at risk?" "The subsurface water is flowing under your property now." "Peh," Tony confirmed. "You should have a structural engineer assess your foundation within the next month." Sandra turned to Karen with fury in her eyes. "You did this? The HOA did this?" "We were trying to fix a problem," Karen stammered. "You created a problem," I said, "and now you're going to fix it properly, or you're going to get sued by multiple homeowners for property damage." That night, I received an emergency call from Douglas Werner. "Peter, we need to talk. Can we meet tomorrow?" We met at a coffee shop in downtown Gilbert. Douglas looked like he hadn't slept in days. "Karen won't admit it, but she's panicked," he said. "We got a letter from Sandra Mitchell's attorney threatening to sue the HOA for the foundation issues. 2 other homeowners on that street have joined her. We're looking at potentially hundreds of thousands in damages." "I told you to remove the concrete properly," I said. "I know. I voted against that second pour, but Karen pushed it through without a full board vote. Now our insurance company is saying they won't cover it because it was an unauthorized modification that made the situation worse. So what do you want from me? Help us fix this. Please. Tell us what it would take to make this right." I sipped my coffee, considering. "Here's the deal. The HOA removes all the concrete, restores my well access properly with a professional water engineer supervising, pays for any remediation needed to address the foundation issues they created, and pays my legal fees and the back-billed water usage up to this point. How much are we talking about total?" "Probably $75,000 to $80,000 all in." Douglas winced. "That's going to require a special assessment on all the homeowners." "That's your problem to solve. But Douglas, if you don't fix this now, you're going to be dealing with multiple lawsuits, a lien on the HOA, and probably personal liability for the board members who authorized that second concrete pour. Karen made this worse, much worse." He nodded slowly. "I'll take it to the board. We have an emergency meeting scheduled for tomorrow night." The emergency meeting was even more packed than the previous one. Word had spread about the foundation issues, and the affected homeowners were out for blood. Sandra Mitchell spoke first, her voice shaking with anger. "The HOA has destroyed our property values and potentially our homes. I've had 2 structural engineers look at my foundation. Both said the subsurface water is causing settlement. One estimated repairs at $40,000. The other said we might have to underpin the entire foundation for $60,000. Phyllis Carter tried to defend the board's actions. We were attempting to address Mr. Richardson's unreasonable demands. By making it worse, Frank Jacobson stood up. I'm a retired civil engineer. What you did was criminally stupid. You sealed an artesian well without understanding the hydrology. That water is under pressure. It has to go somewhere. You turned it into a subsurface flooding issue. Robert Hughes shifted uncomfortably. We thought if we sealed it better. You thought wrong, Frank interrupted. And now we're all going to pay for your incompetence. Karen tried to regain control. We can address this. We'll work with Mr. Richardson to find a solution. The solution is simple, I said, standing. Remove all the concrete you poured. Restore my well access. Pay for the remediation of the water issues you created. Pay my legal fees and the water usage fees you've been ignoring. It'll cost about $75,000 to $80,000 total. That's outrageous, Karen protested. What's outrageous is that you've now cost the HOA more than if you'd just fixed it properly the first time, Gerald said. My client gave you a clear path to resolution. You chose to make it worse. Now you're facing potential lawsuits from multiple homeowners, a line against the HOA, and possible personal liability. Douglas stood up. I move that we accept Mr. Richardson's terms and authorize the expenditure to fix this properly. Seconded, said the fifth board member, a quiet woman named Alice Patterson who hadn't spoken much before. Karen looked around the table, seeing that she was outnumbered. This is a mistake. The mistake was already made, Alice said coldly, when you poured that second layer without proper authorization. I've spoken with our insurance company. They're considering whether to drop our coverage entirely because of this. The vote passed 4-1, with only Karen dissenting. The HOA was going to fix everything, but Karen wasn't done causing problems. 2 days later, I discovered that Karen had filed a complaint with the Arizona Department of Water Resources, claiming I was illegally extracting and selling water without proper permits. It was a baseless complaint. My water rights were grandfathered and didn't require the permits that new wells needed, but it triggered an investigation that tied everything up for another 3 weeks. The investigator, a methodical man named David Porter, came out to review my property and documentation. He spent an entire afternoon going through my records, examining the original well installation, and reviewing the history of the water rights. Mrs. Lansdale seems to think you're running some kind of illegal water bottling operation, David said with a slight smile. I'm not extracting anything. The HOA buried my well. I've just been billing them for the water that's still flowing under their concrete. David nodded. I've reviewed your water rights documentation. It's all legitimate. Senior rights, properly recorded, grandfathered from the original ranch. You're not in violation of anything. In fact, the HOA's actions in sealing your well without proper permits are more questionable than anything you've done. Are they going to face any penalties? That depends. Did they have the proper permits to do subsurface work that affected groundwater flow? I doubt it, David made a note. I'll be looking into that. 3 days later, the HOA received a citation from the Department of Water Resources for unauthorized modification of a groundwater access point. The fine was $12,000. Karen called me, her voice venomous. You did this. You reported us. Actually, Karen, you did this when you filed a false complaint against me. The investigator looked into everything, including your unpermitted concrete work. You brought this on yourself. This isn't over. Yes, it is. The board voted to fix everything. Work starts Monday. You can either go along with it or resign from the board. She hung up on me. But she didn't resign, which turned out to be another mistake. The following Monday, a professional concrete removal crew arrived along with Tony Reeves and a team of water engineers. They carefully cut and removed all the concrete, exposing my artesian well cap. Water was still flowing, pooling against the underside of where the concrete had been. They installed a proper well housing, restored my access, and then worked to address the subsurface water issues affecting the neighboring properties. The remediation took 2 weeks. They had to install drainage systems to redirect the water that had been pooling underground, stabilize the affected foundations, and restore proper grading. The final cost came to $81,000, plus another $15,000 in fines and penalties from the state. The HOA sent out a special assessment notice to all residents. Each household would be charged $250 to cover the costs. The notice explained that the charges were necessary due to unauthorized actions by certain board members that created legal and structural issues. That's when the recall effort started. 37 residents, led by Frank Jacobson and Sandra Mitchell, signed a petition to recall Karen, Phyllis, and Robert from the board for their handling of the situation. The recall election was scheduled for early June. But before that could happen, things took a darker turn. In late May, I discovered that someone had dumped contractor debris and old paint cans down my well. The well cap had been pried open, and approximately 30 gallons of paint, solvents, and construction waste had been poured directly into the water source. I called the Gilbert Police Department immediately. Officer Jennifer Martinez arrived within 20 minutes, took my statement, and examined the evidence. The well cap showed clear pry marks, and several empty paint cans were scattered nearby, apparently discarded in haste. "This is criminal mischief at minimum," Officer Martinez said. "Potentially worse if we can prove who did it. Contaminating a water source could be environmental crimes. Do you have security cameras?" "Just got them installed last week after all this HOA drama," I said, pulling up the footage on my phone. "And look what they caught." The video was crystal clear. Karen Lansdale and Robert Hughes, both clearly identifiable, had come onto my property at 2:30 in the morning. Robert had used a crowbar to pry open the well cap while Karen directed him with a flashlight. Then, they'd dumped multiple containers of paint and solvents directly into the well before fleeing. Officer Martinez watched the video 3 times. "Mr. Richardson, I need you to send me this footage immediately. This is serious. We're talking about criminal mischief, trespassing, and environmental contamination. I need to call my supervisor." Within an hour, my property was a crime scene. Police tape went up around the well area. Environmental officers from the Arizona Department of Environmental Quality arrived to assess the contamination. A detective named Luis Moreno took over the investigation. "Mr. Richardson, I've reviewed the video evidence. It's pretty damning," Detective Moreno said. "I'm going to need you to get an estimate on the cost to clean and remediate your well. We'll be pressing charges." Tony Reeves came back out with a specialized team to assess the contamination. The news was bad. "The paint and solvents went straight down into the aquifer," Tony explained. "We're going to have to pump out contaminated water, possibly for weeks. Then we'll need to test to ensure the aquifer has flushed clean. You're looking at $30,000 to $40,000 in cleanup costs, possibly more if the contamination spread into the surrounding groundwater." "Can the well be saved?" "Probably, but it's going to take time and money. The good news is the aquifer is large and has good flow, so it should flush the contaminants eventually. But this is serious environmental damage." That evening, Detective Moreno and 2 other officers arrested Karen Lansdale and Robert Hughes at their homes. They were charged with criminal mischief, criminal trespassing, and environmental crimes related to water contamination. The bail was set at $50,000 each. The story made the local news. "HOA president arrested for contaminating resident's well" was the headline on Channel 12. The footage from my security camera was played repeatedly, showing Karen and Robert clearly dumping chemicals into my well. The HOA held another emergency meeting, this time to address what they were calling the crisis. Douglas Werner, now acting as interim president, looked exhausted. "First, the board wants to make clear that Mrs. Lansdale and Mr. Hughes acted without authorization or knowledge of the other board members," he said. "Their alleged actions were criminal and do not represent this HOA." "Alleged?" Sandra Mitchell stood up. "We've all seen the video. They poisoned his well." "I have to say alleged until they're convicted," Douglas said. "But yes, the evidence is overwhelming. The board has voted to remove both of them from their positions, effective immediately. We're also going to be responsible for paying Mr. Richardson's cleanup costs, as this directly resulted from the ongoing dispute that the HOA mishandled from the beginning." Frank Jacobson raised his hand. "How much are we talking about?" "Initial estimates are $30,000 to $40,000. That's going to require another special assessment unless we drain our reserves completely." The room erupted in angry conversation. Residents were furious at having to pay for Karen and Robert's criminal actions. Some argued the HOA shouldn't be responsible since they'd acted without authorization. Others pointed out that the HOA's initial actions had created the situation that led to this. I stood up. I don't want to bankrupt the HOA or cause financial hardship to innocent residents. Here's what I propose. The HOA pays the actual cleanup costs as they come in. Karen and Robert, when convicted, will be court-ordered to pay restitution. That restitution can reimburse the HOA for what it paid me. Everyone else shouldn't have to pay for their criminal actions. Douglas nodded gratefully. That's more than fair, Peter. Thank you. The cleanup of my well took 6 weeks. Environmental specialists pumped out thousands of gallons of contaminated water, treated it properly for disposal, and monitored the aquifer until the water quality tests came back clean. The final cost was $37,000, paid by the HOA from their reserve fund. Karen and Robert's trial came in August. I sat in the courtroom as prosecutors presented the evidence, the video footage, the environmental damage reports, the cost assessments, and testimony from the water engineers about how dangerous their actions had been. Karen's attorney tried to argue that she'd been under enormous stress from the HOA dispute and hadn't been thinking clearly. Robert's attorney claimed he'd just been following Karen's lead and didn't understand the severity of what they were doing. The judge, a stern woman named Patricia Valdez, wasn't buying it. "You deliberately contaminated a water source," Judge Valdez said. "In Arizona, where water is precious and carefully regulated, this is a serious crime. You didn't just damage Mr. Richardson's property. You risked environmental contamination that could have affected the entire aquifer. This was premeditated, as evidenced by the video showing you came prepared with materials to pry open the well cap." She sentenced Karen to 18 months in jail with credit for time served, followed by 3 years of probation. Robert got 12 months and 2 years probation. Both were ordered to pay restitution of $37,000 jointly, plus additional fines and court costs. Karen had stood stone-faced during sentencing, but as they led her away in handcuffs, she looked at me one time with pure hatred in her eyes. I felt no satisfaction, just relief that it was over. The HOA situation stabilized after that. Douglas Werner and the remaining board members worked to reform the association's practices. They implemented new policies requiring proper research before any construction projects, mandatory notification of affected property owners, and board training on property law and water rights. The special assessments to cover the costs of the initial concrete removal and the well cleanup came to about $400 per household. It wasn't popular, but most residents understood that the HOA's leadership had made terrible decisions, and everyone had to share the cost of fixing them. My Artesian well was fully restored by September. The water quality tests came back perfect. The aquifer had successfully flushed the contaminants. Tony helped me install a better well housing with a locked tamper-proof cap, and I upgraded my security cameras to cover the entire property. The water still flowed at 38 gallons per minute, crystal clear and cold from deep underground. I had it tested monthly now, just to be safe, but it remained pristine. I even started bottling small amounts for my personal use, which I was legally entitled to do under my water rights. In October, I received a check from the Arizona Department of Revenue for $12,000. It was Karen and Robert's first restitution payment, which the HOA had claimed and was now distributing back to residents to offset the special assessments. Over the next several years, as Karen and Robert made their monthly payments, the HOA would gradually be reimbursed and would pass those savings to the residents who had been assessed. Frank Jacobson stopped by one afternoon while I was working in my yard. "You handled that whole situation better than most people would have," he said. "You could have bankrupted the HOA with lawsuits. You could have made everyone's lives miserable." "That wouldn't have fixed my well," I said, "and it wouldn't have changed what happened. I just wanted my property rights respected." "Well, you made your point. The new board is actually functional now. We're reviewing all the old decisions to make sure nothing else like this is lurking out there." He was right. The new HOA board, elected after the recall, was more careful and professional. They consulted with attorneys before making major decisions, respected property rights, and actually communicated with residents. It was what the HOA should have been all along. I never did bill the HOA for ongoing water usage after they removed the concrete. Once my well access was restored, I had what I wanted: The initial bills I'd sent had made my point and established the legal principle that my water rights were real and enforceable. That was enough. One evening in November, I sat on my back patio watching the sunset over the desert. My artesian well flowed steadily, the sound of moving water a pleasant background noise. I thought about everything that had happened over the past 8 months, the buried well, the legal battles, the contamination, the arrests, the trials. It had been exhausting and expensive, even though the HOA had ultimately paid most of the costs, but it had also been necessary. Karen and her allies had thought they could simply override my property rights because they had the authority of the HOA behind them. They'd learned the hard way that authority has limits, especially when it runs up against documented legal rights. The more important lesson, though, was for the rest of the community. They'd seen what could happen when an HOA board acted without proper oversight, research, or respect for property rights. They'd felt the financial impact in their special assessments, and they'd changed their approach as a result. The new HOA board sent me a formal letter of apology in December, acknowledging the mistakes that had been made and thanking me for working with them to find reasonable solutions rather than pursuing more aggressive legal action. It wasn't signed by Karen, obviously, but it was signed by every other board member and many residents. I framed that letter and hung it in my home office, not as a trophy, but as a reminder. A reminder that standing up for your rights matters, that documentation and preparation are crucial, and that sometimes the right course of action is the difficult one that requires patience and persistence. My water rights remained secure, documented, and unchallenged. The well flowed freely, providing water that belonged solely to me by legal right and historical precedent. In a desert state where water is life, I had something precious and protected. Karen Lansdale served her time and moved away after her release. I heard she'd relocated to Oregon, as far from Arizona water law as she could get. Robert Hughes stayed local, but kept his head down and avoided any interaction with the HOA or with me. Their restitution payments continued like clockwork, processed through the court system and distributed appropriately. The Meadowbrook Hills subdivision eventually settled into a peaceful rhythm. Property values recovered after the initial negative publicity faded. New residents moved in, attracted by the responsive HOA board and the community amenities. Most of them never knew the full story of what had happened, though the veterans could tell tales if asked. As for me, I continued living in my home, working as a commercial plumber, and enjoying the security of knowing I had one of the most valuable resources in Arizona literally flowing beneath my property. I'd paid a fair price for that property, specifically because of those water rights, and I'd defended those rights when they were threatened. Every time I checked my well, tested the water quality, or simply listened to the sound of that artesian flow, I felt satisfied. Not smug or triumphant, just satisfied that I'd stood my ground, protected what was mine, and forced a system that had overreached to acknowledge its limits. The concrete was gone, removed, and properly disposed of. My well access was restored and protected. The water flowed as it had for decades, as it would for decades more. And the HOA had learned a lesson that would benefit every resident for years to come. Respect property rights, do your research, and understand that some things are more important than community beautification initiatives. In Arizona, water is precious. My water was mine, documented and legal and protected. And after 8 months of legal battles, environmental cleanup, and criminal trials, that fact was now unquestionable and respected by everyone involved. I stood by my well at that December evening, watching the clear water flow through the testing port, and I thought about the old rancher who had sold me this property. Eddie Morrison had understood the value of water rights in Arizona. He'd made sure those rights were preserved and properly documented when he subdivided his land. He'd sold me this parcel with full disclosure about what I was getting, and he'd been right about its value. I'd sent him a letter earlier that week, updating him on everything that had happened. His reply arrived the day before Christmas, a short note saying he wasn't surprised the HOA had tried to overstep, that he'd seen it coming when they built the subdivision, and that he was glad I'd stood up for the water rights he'd worked so hard to preserve. He'd enclosed a historical photo of the original ranch, showing the spot where my well had been drilled in 1987, back when this was all open range land. I pinned that photo next to the apology letter in my office, creating a small chronicle of the story. From ranch land to subdivision, from buried well to restored access, from legal battle to criminal trial to final resolution. It was a uniquely Arizona story about water, property rights, and the importance of standing your ground when you're in the right. The Artesian well continued to flow, 38 gallons per minute of crystal clear water from deep underground, a resource that was mine by right and by law. And every drop of that water was a reminder that in the desert, some things are worth fighting for.